All rise. Court of Appeals, Division 1 is now in session.
Thank you. You may be seated. Good morning. We're here for oral arguments in case number IC18-0013, Harte Travelers versus Vasquez and the Special Fund and Ramirez. This case, of course, is consolidated with IC18-0014 through 0018. These proceedings are being video and audio recorded, so we'd be grateful if each of you, as you approach the podium, give us your name and the name of those that you're representing here today. As you know, each side is allotted 20 minutes. The appellant, you may reserve any amount of time to use for rebuttal, but you're in charge of keeping track of that time. The clock on the podium reflects the total you have remaining. Now, keep in mind, we've read the briefs, we've reviewed the record, we have conferenced and discussed the case, and with that in mind, you may begin.
May it please the Court, I am Janet Weinstein of Janet Weinstein PC, and I represent petitioner defendants Harte's Contracting Services, Inc. and Travelers Insurance Company. This case focuses on liability under the statutory employer provision of the Workers' Compensation Act. That particular provision of the Act was among the original Workers' Compensation Act enacted in 1925 and has, in substance, largely remained unchanged since that time. Over the years, Arizona appellate courts have consistently recognized that the purpose of statutory employer liability is not to find other parties to assess workers' compensation liability to when the direct employer does not have insurance. In fact, courts have found that the very purpose of this provision was simply to identify those employers who are truly using employees to do their work, but trying to evade the purposes of the Act by creating a third party or an intricate scheme by which they get their workers to do the work of their business. Other jurisdictions have amended or enacted different statutory employer provisions for the direct purpose of finding alternative parties on which to assess liability when the direct employer does not have insurance. And it's important, to the extent that the Court looks at any of the out-of-state and other jurisdiction case law in this matter, that that jurisdiction has a statutory employer statute that is analogous to ours and focuses on two things: the right to control the work of the contractor by the principal with which the contractor has entered into an agreement, and that the work performed pursuant to the contractor agreement is a part and process of the principal's business. Those are the two elements that must be proven under ARS 23902B in order to impose statutory employer liability. Now, the first component of the test, the right to control test, follows the right to control test articulated in the Restatement of Agency, Section 220. The Restatement of Agency lists quite a few factors that are to be examined to determine what kind of control is being exercised. Courts have recognized in Arizona, not in the context of workers' compensation cases, but in the context of other cases, that when determining if a general contractor has control over a subcontractor, the responsibility of the general contractor to secure and keep the work site generally safe, to supervise the timing and the order in which the subcontractors perform their work, and to make sure that all of the work occurs in a timely manner, is not the type of control that would lead to a right of control over the specific work being done by the subcontractors. Now, turning to the analysis of the right to control in this case, there are 6 awards They are nearly identical, save one or two paragraphs in each award that summarizes that particular applicant's testimony. The awards lack significant factual findings other than reciting testimony given by each of the parties, and there were overall in these 6 consolidated cases 10 different witnesses. So the witness testimony is very briefly summarized in the awards. To the extent that any conflicts exist, and the respondents have tried to create the existence of conflicts in the evidence in their briefing, those conflicts were not resolved by the ALJ. The ALJ basically concluded that Harte's contracting service had a right of control over its framing subcontractor, Vasquez, and did not go to the trouble of explaining the facts on which that legal conclusion is based, nor did it explain which of the factors under the right to control test it found compelling to lead to that conclusion.
Well, you don't dispute that the general contractor would have some rights of control over the sub.
The general contractor has some general rights in terms of making sure that the subcontractor is performing timely and is basically following some general rules to keep the work site as a whole safe. But the general contractor does not, and in this case did not, retain any right to control the actual framing work of the subcontractor. Framing is really the skeleton, and I apologize if you judges already know a lot about construction. It's the skeleton.
I was just going to say, I mean, the problem that I think you're arguing for with regard to the award isn't that there's anything specifically wrong about a conclusion that the general contractor has rights of control over the sub. You're just saying that doesn't go far enough to establishing the necessary individualized control over the work and the people doing it.
Correct, and thank you, Your Honor, for clarifying that. The right of control has to be over the particular manner and means by which the work is done. So if the general contractor told the subcontractor, here are the plans and specs, go get that built, and walked away, which is what happened here, there's no control over the manner and means by which the work gets done. But if the general contractor said, here are the specs, go build this, but I want you to start on the sanctuary and start at this end, and when you frame the walls, I want you to do it this way and frame them all on the ground and then lift the walls up, that would be giving instruction on the particular manner and means about how framing work is to be done.
Does the fact that the contractor subsequently stepped in and paid these employees directly, is that a fact of any significance to the legal analysis here?
The contractor did not pay the employees directly for the work being done, and that there is nothing in the evidence that establishes that. At best, that's a conflict in the evidence that the ALJ did not resolve clearly and directly in the award. The only thing about that problem with the subcontractor that is mentioned in the award is that there was a dispute between the subcontractor and his workers about payment. The general contractor, when he saw that the workers just stopped working, he wanted to know what was going on and said, I will go talk to the subcontractor, but please just keep working. That situation was referred to in the award as there was some dispute about payment and Harte's contracting got involved. But it doesn't say the extent to which they got involved or anything further. Although the respondents may argue that Harte's stepped in, gave them direction, there's nothing in the record to establish, and to the extent it's in the record, it is contested because both Mr. Harte, and Mr. Rascone, someone he asked to come over to translate because he does not speak Spanish and these workers spoke Spanish, both testified there was no promise to pay. So to the extent that there's anything in the record that conflicts with that, the ALJ should have resolved that but didn't resolve that. It's important in the context of construction cases also, and both the Ovadia case in New York and the Harger case in New Mexico, both the courts, the highest courts in both states, had to deal in a construction situation about assessing the right of control by the general contractor over the subcontractor. Both courts acknowledged that applying the restatement factors or any multi-factor test in isolation in the construction industry is very difficult because some of the factors seem to be resolving towards what would normally be an employment relationship, like controlling the place where the work is done. But in this case, that factor is dictated by the nature of the work and really doesn't bear upon or shed any light on the nature of the relationship between the parties. So those courts make some very good points about what needs to be focused on in the construction industry.
What was the first of those two cases that you just mentioned?
Ovadia, O-V-A-D-I-A. I believe it is cited in the opening brief, New York State Court of Appeals, 2012. Because I would like to reserve some time for rebuttal, I want to focus now on the second factor under the test. Before I do that, let me make one point. Because of this court's decision last week in Aguirre, in terms of the requirement for an ALJ to make specific findings so that the legal conclusion reached can be adequately assessed, I think it is important that the principles decided in that case be applied here. And the fact is, in terms of the right to control determination made by the ALJ, significant facts were either not made in the award, purported conflicts were not resolved, and therefore under Aguirre, the right to control was not properly decided, and on that basis alone, the award needs to be set aside. But going to the second element of the right to control test, the ALJ concluded that the framing work falls within a regular, ordinary, or routine business operation of the general contractor's business. This misses a really important distinction. Superficially, yes, framing, plumbing, electrical, HVAC, it's all part of a general contractor's business. It's all part of the construction industry. But it's not a business process, which is the statutory language here. And it has to be a regular, ordinary, or routine business process of a general contractor. The general contractor in this case, and in most cases, the business process of a general contractor is not to do the specific trade work and perform that trade work him or herself through his or her employees. The general contractor subcontracts out the trade work to separately licensed, qualified professionals to do the work. The essential distinction is why general contractors' routine business operations do not per se encompass the specialty work that the subcontractors are licensed to do. This was precisely the issue addressed by Judge Thompson in an unpublished decision, AJF Custom Homes, in March 2015. It is the exact situation as exists here. In AJF, AJF was a custom home builder. It took a piece of dirt and built a fully furnished home to sell for a family to move into. AJF used a stucco contractor to finish the exterior of the home. On this particular job, the stucco contractor subcontracted out the whole job to a second subcontractor that did only stucco work, and that subcontractor's worker was injured on the job. The worker alleged that AJF was the statutory employer because if you are a home builder, all aspects of construction of the home are part of the business. The court explained that under 23902B, AJF was a general contractor in the business of building custom homes, but it did not itself or through its employees actually physically build anything. It hired licensed subcontractors. It scheduled the sequence of work. It got permits. It got inspection approvals from the city and county authorities at every stage of the work. There are a lot of responsibilities and duties of a general contractor, and that is a core part of the general contractor's business, but actually performing the subcontractor's trade work is not a core part of the general contractor's business, and that's precisely what the court said in AJF. Since I want to reserve 5 minutes for rebuttal, in summary, the petitioners would ask this court to set aside all 6 of the awards for the following reasons. Neither the ALJ's findings nor the undisputed evidence constitute substantial evidence on which to impose statutory employer liability on HCS. HCS did not retain the right to control the details, the manner, or the means by which the 6 injured workers did the framing work. The evidence does not satisfy the first requirement of 23902B. And as I just said, based on the AJF case authored by Judge Thompson, as a matter of law, the second element cannot be satisfied under these facts, because a general contractor that does not actually do any of the building work itself, and in this case it's been established that Harte's subcontracted out all of the work necessary to build the church, did not do any of it himself. The general contractor then is not, the subcontractor's work is not a part or a process in the trade of the general contractor. Thank you very much.
May it please the court, my name is Chris Norton from Norton and Brosina PC, and I represent the Special Fund Division No Insurance Section. We believe that this is a routine application of the statutory employer doctrine. We submit that the statutory employer statute was properly applied in this case. In fact, we submit that the case demonstrates the very evil that the statute was designed to remedy. And just to start out, I would like to kind of touch on at least two of the purposes of this doctrine. The first is that it ensures coverage for employees of uninsured contractors. That is one of the primary purposes of this doctrine. And Larson's has said that the purpose is to protect the employee of irresponsible and uninsured contractors by imposing ultimate liability on the presumably responsible principal contractor who has within his power in choosing subcontractors to pass upon their responsibility and insist upon appropriate compensation protection for their works.
Sounds to me like you're kind of conflating two purposes of the statute. There's the public policy that injured workers will have coverage and receive medical and disability benefits as appropriate. That's why the special fund got created. But what you're really talking about is the fund's ability to collect for the expenses it pays out for those employees.
Well, I'm not sure I follow that, but I think that the purpose of the statutory...
Well, my point is that there's any number of employers that do not obtain and provide workers' compensation benefits.
That's correct.
And there are any number of injured workers who receive the benefits from the special fund, and there's no collectible recourse for the fund because the employer's bankrupt or gone, can't be found.
That's correct. The special fund does stand alone for other purposes, but the special employer doctrine is the purpose of that is to ensure that, as counsel stated, one is that the employers aren't doing their own work through the use of subcontractors. But I think an even more important purpose of this is to make sure that there's coverage for uninsured contractors, and construction is the major offender of this. And I think it's important to recognize that this is where most of the abuse is, without using subcontractors who aren't insured. And so I think that is the purpose is to protect them and to.
So do you have some Arizona case law where where this doctrine has been applied in this type of setting, where it's a general being found as a special employer or statutory employer for subs, where the relationship is truly a contractor subcontractor.
I'm not sure I could. I know there are cases that have addressed it both ways. Most of the cases are shield cases where the employer is trying to.
Right.
They're trying to use it as a shield. There are cases that, probably most of the ones that I'm aware of find that that it's not adequate, not finding the relationship there, the both prongs. But I think that this is an unusual case where a GC, where Harte's Contracting was acting as a general contractor, but really they were acting as much more. They took this way further than a normal general contractor. A normal general contractor is protected if they only exert enough control to effectuate the end result. This one was actively involved in trying to reduce the cost of this church that they were building by a third. They were trying to build a $3 million building for just over $1 million. And they were cutting corners to do that. And one of the corners that they cut was securing labor through an uninsured, inexperienced, largely absent subcontractor, which we maintain was basically what Larson's calls a dummy intermediary. And I think that's what this is.
I missed this. Did the ALJ make findings to support the conclusion that you're stating?
Well, the ALJ summarized all the testimony and made findings on both prongs of the statutory employer doctrine.
I'm sorry, my question was for, did the ALJ make findings that there was that the sub was a dummy arrangement?
No, he didn't make a specific finding to that effect, but the evidence, I know you've read the record, but the evidence is very strong that even the least, to give you an example, even the least experienced framer testified that the so-called subcontractor, Raphael, didn't know what he was doing. He did not know what he was doing. And that project was being led by some of the other more experienced framers. So I think there's plenty of evidence to suggest that this was basically...
So the project was being led by the more experienced framers. Was there evidence to suggest the project was being led by Mr. Harte?
There is. There's testimony from many of the framers that say that when they had a question, they would go to Justin Harte or his father, or to, and they had some interaction with another, Diego, who is also a representative of Harte. Although, there's conflicting testimony for sure on it. But many of the framers said that they would go to Harte's if they had questions on the plan. And all of the framers, I think without exception, said that Raphael, who was the main supposedly the subcontractor in charge, didn't know what he was doing. And so they relied in part on some of the more experienced framers and in part on Harte's Contracting and the people who were there on a daily basis supervising and directing the work, which we believe was in excess of what a general contractor can do and still be protected.
So the rule that we would get out of this is if the employees of a subcontracted trades group or tradesmen ask questions of the general contractor, that transforms what otherwise would be a traditional general sub relationship into a statutory employer relationship. Is that?
I'm not sure that just asking them a question is enough, but they provided materials, whether that's through the church, and it came through Harte's. They provided equipment, including a crane and other small equipment. They mixed.
And this was unusual from. Are there findings that these arrangements, this provision of some materials, this provision of some equipment was atypical or unusual from a contractor, subcontractor? I guess I'm looking for what are the findings that the ALJ made that get us to the legal conclusion here?
I think that I don't know that the judge made specific findings on, hey, because they got the crane, therefore they're the employer. But they're looking at it's a totality of the circumstances test, and he's looking at all these factors, including their involvement, which includes a framing contractor would probably bring in their own crane. But in this case, the general contractor is bringing in.
Is there any record of that? I mean, I don't have any experience in this. I don't know if you do, but why do we take your word here?
Well, because you asked me, but I mean, you asked me if it's typical. I don't think it is. But it's.
I guess I would prefer that we point to things in the record.
Okay.
And so that's my question. Is there anything in the record to suggest that this was an atypical or unusual contractor-subcontract relationship? And if that's what you're relying on, please point us to the places in the record that support that.
I don't know that there was any testimony taken from any experts on what was typical and not. It was more of testimony about their involvement in the day-to-day operations. And when you look at that day-to-day, they're there on a daily basis. Most of the framers said that Harte's representatives were there more than than Raphael, who was supposedly the subcontractor.
I think maybe one of the questions Judge Perkins is asking was that in that testimony, did the framers say that they were being directed by Harte's representatives as to what to do, how to do it, other than general scheduling?
Well, I can give you one example that's in the record that comes to mind, and that is, it's a significant one because it's when the accident occurred. They're having after a break, the framers won't go back to work because they're claiming they haven't been paid on time or hadn't been paid that week. They want to be paid cash. They want to be paid weekly. They weren't going to do it, and so Harte brings in, I believe his name's Diego, as a translator, and basically said, the crane's here. We've got to get this done. Don't worry about payment. We'll make sure you're paid. And from our perspective, directs them to get up on and do the trusses, and that's when the accident occurs. So there is evidence of them specifically directing them to do certain activities and supervising and controlling those activities.
Okay, in my mind, at first blush, that sounds like scheduling versus the mechanics of how to do the job. So share with me how you distinguish that.
Well, I guess he's not telling him. One, he's intervened in a wage dispute with employees of a sub, and then he's basically telling them, you've got to get this done. You got to do it now. We don't even know if Raphael was there at the moment, but get up on there and we'll pay you. Don't worry. That's more control than a typical general contractor is going to exert over employees of a sub. That's more intervening in a wage dispute and telling them to get up on top of the roof and hang things is different than a normal interaction with a GC. And that's all the case law says. You're protected as a GC as long as you only do what's required to effectuate the end result.
Did the ALJ in the decision identify that testimony or those facts as being critical to the legal conclusion that there was control?
I think that the line that I recall in the decision upon review was that he relied on the testimony of Justin Harte in finding that they had sufficient control and that it was part and process of their work.
Do you think that sort of indirect finding or conclusion satisfies what this court said in the recent case cited by counsel?
Well, I think Aguirre certainly extends post, and as a practitioner, we would like more detail, I think, a lot of times in decisions, but I think that his award and his summary of 6 different injured workers' testimony was sufficient to satisfy Post and Aguirre. I think it's sufficient, but I think Aguirre is an important decision, because we would like to have more details too of how you reach the conclusion, but that really hasn't been the practice of administrative law judges. They summarize the facts, the testimony. They generally will try to resolve clear credibility issues, meaning findings of, I find this witness credible and this one not. I think this is a difficult case because there's no way in a typical decision upon hearing the judge could have resolved every factual dispute in this case, and I don't think that's necessary. But there's probably some middle ground. But I do think that this decision, it satisfies both Post and the recent decision of Aguirre. One thing that I wanted to touch on too is that I think it's important to remember that the lens that we're looking at, also Young versus Environmental Air Products, basically said this particular statute should be, well, we know this. We know that there's case law that says that we should liberally construe all the Workers' Compensation Act in favor of granting compensation. But specifically with the statutory employer, the statute should be liberally interpreted in order to impose liability on workers' compensation benefits, but strictly interpreted when an employer is using this statute as a shield. And we've touched on that a little bit, but most of the cases that we have are shield cases where the employer is actually using it. So we maybe don't have clear direction from this court or the Supreme Court on how that applies. But in Word versus Motorola, it says this section should be construed as broadly as necessary to prevent the evil perceived, but should not be stretched to defeat common law third-party tort liability. So I do think it's very clear that this statute, the purpose is to encourage, at least in part, is to encourage general contractors and subcontractors to make sure that their employees are covered, and also their subs, the employees of the subs, are covered. And I think it's important to note that this court should be liberally construing that in order to effectuate that purpose, and to cover these injured workers, and to encourage the construction industry, frankly, to make sure that the people they're hiring as subs have coverage. Just to give you an example, if an employer comes into my office today and asks me, Mr. Norton, what can I do to protect myself against a workers' compensation claim? The only advice I can give him is make sure you have your own workers' comp coverage, and make sure any sub under you also has coverage. They didn't do that. They didn't check. This project was 80% complete before this accident, and they had not verified Raphael's status as with the Registry of Contractors. They not verified insurance, and they clearly didn't check out his, although there was testimony that they had some positive reviews from others, they clearly did not check out this guy's work or his experience. And that's not the type of activity that we need to be encouraging in this state, and telling all the GCs that you're safe because you don't build anything. That's not the right message that we should be sending. The message should be, if you get involved, actively involved, like Harte's Contracting Services did in this case, they got actively involved to save money. They were trying to build a church. That's admirable, but you can't do it at the expense of the labor that they secured for this. And I think that goes to also to the. I think the record is clear that there's lots of instances where they were so involved and so closely intertwined with this project that all these individuals thought that they were the employer. In fact, all of them filed claims against them. Raphael was only brought in later at hearing. All these people listed Harte's Contracting Services as their employer. They all believed that Justin Harte was the boss, they were very involved in it. And it might have been for good reason, but I think that takes them away from the general protections of the general contractor situation. We're not asserting a position that every GC, just because they have subcontractors, is exposed to is automatically the joint employer. I think in their brief they kind of suggest that that's what the position we're taking. It's not. But there's a continuum of involvement. And the case that she cited, the AL, the decision written by Judge Thompson, AJF case, is totally different, because that general contractor did not provide materials. He did not provide equipment. He was not actively involved and on the site all day interacting with the contractor. And they found in that case that there was a lack of control. But I think in this case there's significant evidence that he exercised of control, and I think that an argument can be made too that when you secure your labor through this basically a sham subcontract, that becomes part and process of what you're doing. They're using essentially a glorified interpreter to distribute funds, and that's how they secured the subcontract work for a framing of a church. And I don't think that should be excused. And I think that they definitely had the right, not only did they retain control, but they exercised supervision and control in almost every manner over this subcontractor and the subcontractor's work, which was the framing. And I think it has to be deemed. I see my time's expired. Thank you.
Let me start by addressing Council's reliance on Larson for the public policy and the intent, the legislative intent behind the statute we are dealing with here now. Larson's cannot speak, it's a treatise, and it cannot speak to our legislature's intent. Our legislature's intent has not changed since 1925, when the statutory employer provision was included in the original act, as I stated earlier. In 1931, the Arizona Supreme Court, in the Grabe decision, Grabe, said very clearly that the purpose of this statute is to make sure that an employer isn't coming up with a sham arrangement to basically avoid its responsibility to pay its employees. So there has to be some kind of sham, fraudulent arrangement going on. There is nothing to suggest anywhere here that Harte's Contracting Services hired Vasquez as a framing contractor in order to avoid paying its own employees. Harte's Contracting, the record shows, has only 6 or 7 employees. It subcontracts out the work. Since the Grabe decision in 1931, Arizona courts in Basurto and in Molnar more recently reiterated that the purpose of the statutory employer statute is not to, as suggested by counsel, find another party when the real employer doesn't have insurance. The purpose is to truly and accurately identify who the real employer is. And I suggest here that the real employer was Mr. Vasquez's framing company. Now, I need to address a lot of these other allegations about what the framers said, and the framers said they took direction. The record is very clear, and in fact, Mr. Norton referred to the testimony of one applicant who said that when they had questions, if Mr. Vasquez wasn't there, they would go ask Justin Harte or someone from Harte, and they would get the answer. But that very same individual specifically testified, and this is in the petitioner's briefs, that no, they didn't tell us what to do. We didn't see them very much. We didn't get direction from them. So the very witness that they are relying on to suggest that Harte's exerted control over how the work was performed said, no, we didn't take any direction from them. Very important, it's an undisputed fact that Justin Harte does not have expertise in framing. He testified that he doesn't know how to do framing for a church of this scale. He, prior to this job, Harte's contracting services didn't have a license to do a job of this scale. It got its commercial contracting license specifically so it could start doing jobs like this and for this job. So Justin Harte's experience in framing and was minor remodeling of existing structures. It was not to build a new structure from the ground up, and he subcontracted it and relied on the subcontractor. That is not a disputed fact. Justin Harte does not speak Spanish. That is not a disputed fact. How could he, and you will notice in the transcripts here, all of the applicants required translators. They do not speak English. That is why when the wage problem came up, Mr. Harte called Diego Rascon, a colleague of his, to come and translate to find out why they stopped working. How could a project go on for 6 weeks and Mr. Harte purportedly instructing them on the nuances and details and specifics of the work when he doesn't even speak their language? So there are a number of undisputed facts that completely refute the characterization that the respondents give to the record here. More importantly, if you look at the awards that were issued in this case, when Mr. Harte the ALJ found that Mr. Harte contracted with Mr. Vasquez because he came recommended from other commercial builders. There is no finding that he contracted with Mr. Vasquez in order to avoid hiring his own framers or doing the work himself or to create a sham situation. He spoke to other commercial builders and got an experienced contractor. I would go on because I have so much more I could go on with, but the time has run out. Thank you very much.
Thank you both for your arguments. We'll take the matter under advisement and issue our decision in due course.